Well, hello and welcome to today's HIPAA Chat. I'm Carol Feig of High Tech Answers, part of the Answers Media Network. Thanks for joining us. Our conversation today is around non-HIPAA issues that organizations need to address for health data, privacy, and security. If you're new to HIPAA Chat, thanks for joining us today. This is an opportunity to engage and pose a question to our expert, who we'll talk about in a minute. HIPAA Chat is sponsored by Effects Corporate, a brand of J2 Cloud Services. J2 is an award-winning leading provider of internet services through its two divisions, its business cloud services and digital media. If you'd like to learn more about eFax, you can check out enterprise.efax.com. And they have several products related to the secure transmission of ePHI. Move on. Our host and expert is back with us again. It is David Harlow. He's a healthcare lawyer and consultant with over 25 years of public and private sector experience. He focuses on digital health law and policy, starting with HIPAA, state law, healthcare data privacy, security planning, and he works with covered entities, business associates, healthcare providers, organizations, and all manner of companies operating in the healthcare space. You can visit his award-winning blog, which is www.healthblog.com if you're listening to this only. Check out his blog there. He writes regularly about topics impacting security and healthcare data. And you can contact him directly at david@harlowgroup.net. You can find our past HIPAA chats on YouTube. We have a channel there where we put all of these events up there as recorded videos. You can also listen to them as podcasts on our radio station website. Under HIPAA Chat, you'll see an archive of podcasts. We also stream HIPAA Chat, the latest HIPAA Chat, on our Healthcare Now radio station at 12 noon and 7 p.m. Eastern. And finally, you can follow us and engage with us in our HIPAA Chat group on LinkedIn. If you go to LinkedIn and go to groups and search for HIPAA Chat, we will pop up. So David, it's March. I'm back from HIMSS. We're back together again. We had a great cybersecurity panel discussion in February that was really well attended. Again, people, you can find that on YouTube as well. We did a cybersecurity panel discussion with a bunch of experts. That was very informative. And now we're back to our regular monthly HIPAA Chat. And I think we've got an interesting topic today to talk about, and as we sort of review some of these issues, please use the question toolbox found on the GoToWebinar dashboard to ask your question. We will leave plenty of room for Q&A. It's what this program is predominantly about. So David, this is a topic that you're interested in and you've written about, and I think are some of these things that people don't actually think about when they think about HIPAA. It's why we call it non-HIPAA issues, I guess, right?
Right. We're going beyond HIPAA today. I mean, it's hard to leave HIPAA behind entirely, but it's certainly important to remember that there's plenty of issues beyond HIPAA when we're thinking about healthcare data, privacy, and security. There's a whole host of federal three-letter agencies that we have think about in this realm, and of course every state regulates personal data in its own special way. I've been dealing this week with some California issues, just for example, and California is often more protective of personal health data privacy rights than the federal rules are. And certain types of data come under state protection that aren't even touched by HIPAA. So that's something to think about. And as I mentioned, there are other federal agencies that come into play even where HIPAA is not an issue, even if something is not PHI, protected health information under HIPAA. There's certainly other potential for coming into contact with the federal government.
So yeah, right. In California, I would imagine, I mean, there are some states that obviously just have a lot more legislation that must be dealt with.
Right, and certainly, I mean, from the From the healthcare provider perspective, most providers are still relatively local, although obviously there are some providers that provide services across numerous state lines. But there are other entities that are governed by HIPAA, in particular the healthcare providers' business associates, which have to contend with, in some cases, all 50 states and their different rules and regulations. If you're on the, for our listeners out there, if you're on the business associate side, this is something to always keep in mind. The need to comply with federal HIPAA rules, other federal rules, and then again, 50 states sets of rules. And if you're on the healthcare provider side, if you're dealing with a business associate, if you're engaging on a contract basis another company to help you with some aspect of your data management, data processing, communications, you need to be confident that your service provider is compliant with everything that affects you and your data, wherever it's located. So that's something that is sometimes easy to overlook, but obviously important.
Yeah, that's a great segue into the first thing that you really wanted to talk about, and I'm sure we'll get some questions from the audience about this, which is, wearables and wellness programs, which is, of course, ubiquitous these days, right? As far as patients and their wearables or devices and wellness programs, all good, obviously, from a sense of people wanting to, proactively be involved in managing their health. Yet there is a security and privacy issues involved.
Right, right. So I wanted to start with wearables and the notion of wellness programs, and sometimes the wellness programs provide the wearables to individuals, because this highlights one of the issues that I wanted to focus on today, that you could be using the same Fitbit on your wrist, but depending on how it ended up there, that Fitbit could be governed by two entirely different sets of regulatory structures. So if I go down to the local store and buy a Fitbit and slap it on my wrist and connect it to my smartphone, that is purely my data, my information, my personal health record information that may be stored by a Fitbit app or by a other smartphone app that I'm using that's connected to the Fitbit. But if that Fitbit is provided to me by my employer's health plans, wellness programs contractor, we're start to be in a different zip code, if you will.
Okay.
Or if that Fitbit is provided to me by my doctor's office or by my insurance company. Some insurance companies have started passing out personal trackers of one sort or another. And this brings us into a whole different kind of situation where that is governed by HIPAA. The data is governed by HIPAA because it is going from you, the individual, to a covered entity under HIPAA, whether it's a health plan or through the health plan to a wellness program or to a healthcare provider, where data is being fed into the provider's health record that can be correlated with other information, including clinical information. So, same data, same thing on your wrist, same connection to your smartphone, same connection to your computer, but the way in which that arrived on your wrist and the way in which the data is connected to other upstream entities will determine the way in which that data is governed. Is it covered by HIPAA? Is it not covered by HIPAA? Many of you on the call today are coming at this from the perspective of the healthcare provider world. So for you, if your organization or patient's health plan has provided the wearable, then that data is covered by HIPAA. If it is information that is being provided to you because an individual patient is just dying to give you their Fitbit data and their workout data, and you can't say no, and they send it to you even if you do say no, that is sort of coming at this from a different angle. Once it's incorporated into a health record, of course, it becomes protected by HIPAA. But as it is used by the patient, that does not come into play. So there's sort of different ways in which we deal with the same data under different approaches, depending on how it's being used. Now, the wearable companies may be involved in research projects and may be using that data that comes from an individual. Again, if it's not running through any covered entity under HIPAA, then it's not covered by HIPAA, but it is covered under Federal Trade Commission rules around privacy and fair practices. Dealing with that data in a way that is not up to snuff from a privacy and security perspective, from a end user permissions perspective, would get the wearables company or anybody else who's trying to do some work with that data into some hot water.
Wow.
And on the positive side, over the past couple of years, some of the companies in this arena have been collaborating with the federal agencies in order to make sure that they have appropriate safeguards and protections in place so that the regulators, and by extension the general public, can feel more comfortable about how they're dealing with their personal data. Again, even if it's not protected health information under HIPAA, it's still personal data that individuals may be concerned about.
And that's, you're talking about data, where obviously we were talking about data this entire time, but when you sent me your bullet points, I wasn't surprised about the wearables and wellness programs. I was surprised, I guess, by population health. It never entered my mind, but you know, I just came back from HIMSS in Orlando last month, and population health was definitely one of the big topics talked about, and from an exhibit standpoint. And so here it is, popped up on our HIPAA chat.
Right. So here the question is, well, what do we mean by population health?
Right.
A lot of people mean different things when we say population health. But as someone with a public health background, I think of population health as dealing with the entire population as the patient rather than the individual as the patient. And when we're talking about the population as a patient, we're interested in looking at all sorts of data and interrelationships among different types of data that relate initially to an individual but need to be aggregated in order to manage the population's health as opposed to the individual's health.
Right.
We're all familiar with the notion of population health from discussions of immunizations and herd immunity and the questions around people choosing not to be immunized, right? So our concern is about the population, not just about the individual. When we're talking about population health agencies have HIPAA-related obligations to the extent that they come into contact with protected health information. So if you are operating a physician practice and the local public health authority comes looking at you for data about whether it's an infectious disease outbreak of one sort or another or something else entirely, sharing that data is permitted under HIPAA. So someone's first reaction might be, oh, I can't give you this information because it's protected by HIPAA. So from the healthcare provider perspective, just be aware that population health activities carried out properly by a public health agency would include the collection of this data, and you don't need additional permissions or protections to be HIPAA compliant. Whole other area, and this gets into the what do we see on the exhibit floor at HIMSS department. There are a tremendous number of tools available that can help with management of population health. Now here I'm talking about sort of narrower populations, whether it's my patient panel if I'm a physician, whether it's my insureds if I'm an insurance company, whether it's my employees and their dependents if I'm an employer. I want to make sure that their needs are being addressed in a way that is appropriate. And part of the way that I can ensure that is by getting a lot of information from them, asking them a lot of questions, tracking a variety of different kinds of data. So to a great extent today, a lot of this is carried out through smartphone apps. And that, of course, triggers a whole other set of issues, not limited to HIPAA, but certainly HIPAA. What issues other than HIPAA are triggered by the use of these smartphone apps? Well, again, if it's within the context of healthcare services, then HIPAA is going to be front and center. But other issues will also be applicable. As we mentioned already today, Federal Trade Commission protections are also in play, and state health, personal information, personal data, privacy and security protections come into play as well. So those are the kinds of issues that cut across all of these domains.
Right, and you're absolutely right about the app thing. Walking the exhibit floor there, almost across the board, all of these companies that had pop health solutions, they were all predominantly app driven. Right.
So for those app developers and for those service companies, their customers, generally the healthcare provider system, or the ACO, or the payer, or sometimes the employer or the employer-sponsored health plan.
And then, of course, you wanted to touch briefly about just software programs in general, obviously.
Sure. Yeah. So across all of these domains, I think it's important to think about the fact that there are a tremendous number of different sorts of risks out there. So this is just sort of a multi-dimensional matrix that we're dealing with in terms of health data privacy and security. And it continues to blossom and expand in terms of what risks there are out there. In the past year, there have been just a tremendous number of incidents where unauthorized access to data has occurred one way or another, whether it's by a hack, whether it's by theft or loss, whether it's through some sort of ransomware or a phishing expedition, so to speak. And the overarching theme here is that we need to identify the risks and the vectors for security breaches and try to address them as well as we may. To a certain extent, these continue to be technical issues, and the healthcare domain seems to be a little bit behind other domains in terms of protecting data appropriately as a whole. Obviously, there are plenty of people who are doing good things, but the sector as a whole has experienced tremendous number of breaches and so forth, and we have a big target painted on our collective back because of the richness of the data sets.
Yeah, there's documentation out there that suggests the average stolen medical record has a street value of about $500, which is a lot.
Right. I mean, it's more than a bank record, credit card record, etc.
Right.
So tremendous increase in attacks, tremendous increase in number of records compromised or subjected to ransomware, which seems to be the hack du jour, so to speak.
Right.
And that's what our concern is about. So when I say software, I'm also thinking about web-based services, which means that we need to be sure that people on staff using the various web-based services that we have, whether they're full-blown EHRs or other sorts of web-based services that are needed in order to run a practice or run a population health program or anything else that we're talking about here, we're back to sort of square one. We're back to real basics. So when I say that these are not HIPAA issues, these are much more fundamental issues about encouraging a culture of compliance, about a culture of privacy, about a culture of security, about not having passwords on a sticky note on the monitor. This still happens, folks. Hopefully not in any of your places of business, but it still happens, shockingly enough. A Secret Service agent had an unsecured laptop stolen from his car this week in New York City.
I saw that, yeah.
Is that crazy?
Yeah, it's crazy, yeah.
So this is still happening. A lot of dumb stuff is still happening. And my plea to all of you listening is don't be dumb.
Yeah. And
don't let this be you.
Right.
If you read these stories about the unencrypted laptops or the things stolen from the backseat of the car, you think, oh my gosh. I think, oh my gosh. At this moment in time, how could someone with that kind of information be so careless? It's an avoidable incident.
Right.
Easily avoidable incident.
So before we jump into our Q&A, I think you wanted to spend just a couple of minutes talking about this current class action suit that's going on. Speaking of stolen laptops, it was a good segue. That's going on, and you've written about this on healthblog.com. So if we maybe just talk about that for a few minutes, and then we will jump into our Q&A with our audience.
Sure. So this is I'll try not to geek out too much on the details here, but the interesting thing about this case is that this is a class action that was brought, and the question before the court where we're looking at it is, can this proceed as a class action? They haven't sort of made any sort of final finding that people's rights were violated or somebody is liable, but the way the decision's written so far it looks like the court is pretty open to finding a finding of liability here. So let's sort of sketch out the issue. There's a stolen laptop with a whole bunch of patient data on it. This is one of these classic stolen laptop cases, and an unencrypted laptop. Under HIPAA, as you all probably know, there's no private right of action. It means an individual person can't sue under HIPAA. It is the government that can take action under HIPAA. However, there are other ways in which people can sue. Under state law, under common law, under state law, general principles of privacy, it's possible to bring a lawsuit. This case talks about a new legal theory. Okay, so the Fair Credit Reporting Act creates a duty of care to consumers owed by consumer reporting agencies. The definition of consumer reporting agencies is pretty broad, so health insurance plans are considered consumer reporting agencies. The laptops in question were held by a Blue Cross Blue Shield plan, and they were stolen out of a car or whatever. So the insurance company losing a laptop with unsecured PHI on it now becomes a potential violation of the Fair Credit Reporting Act.
Mm-hmm.
And there's some pretty severe penalties under that for someone who violates it if you're a consumer reporting agency. So what the court did here is basically said this claim may proceed. And they made a pretty strong statement, as I said, about how this really looks like it's covered by the Fair Credit Reporting Act, and chances are high that in the end the defendant would be liable here. So this sort of new frontiers, so to speak,
right,
in HIPAA land, where we're moving out of HIPAA land and into other areas. Now, if you are a covered entity, you need to be really concerned about stuff like this, because there's a potential for tremendous liability under some of these statutory schemes that are set up as consumer protection schemes. People are familiar with this from other parts of parts of our lives. We're all familiar with this when we're consumers, and we want to be able to, bang the table and assert our rights. When we're working on behalf of covered entities under HIPAA, seeing this looming as a potential tool for enforcement, I think should worry all of us.
Mm-hmm. Well, we'll have to see how this turns out, and follow this on our continuing series of HIPAA chats, because I would imagine it'll eventually get resolved one way or the other.
That's right.
Yeah.
It should be interesting to follow.
Yeah. So we're going to keep tabs on that one, because that's sort of a game changer. All right, so we're going to start taking questions from our audience, and you can pose your question, as I said, using the dashboard, the question dashboard found in the GoToWebinar tools that you have in front of you. And if we don't get to your question, I've provided David's email, which is david@harlowgroup.net, and certainly you can always email me, carol@hightechancerous.com. Remember to check out his blog, health blog, blawg.com, and of course follow him on Twitter. All right, so as usual, we leave about 30 minutes for Q&A, so I'm just going to dive right in. And one of the things that you talked about under software programs, you actually talked about, a culture of privacy and security. And one of the questions that we got from our attendees is, what would be a good strategy to get upper management's buy-in on IT privacy and security?
That's an excellent question, and the pervasive problem in healthcare is that most organizations do not devote the requisite percentage of their IT budget to security efforts. It may be a particular concern for smaller organizations, but this holds true across the board. Larger organizations as well are just simply not devoting the necessary level of resources to security within an IT budget. If you look at the financial services industry, the level of funding for these efforts is much higher, and the level of breaches is much lower.
Right.
We've come to rely upon all kinds of IT-related services in the financial services industry, and in a sense, part of the problem is we're playing catch-up because of the tremendous explosion in IT and healthcare under the Meaningful Use Incentive Program. So the tremendous growth accelerated, and without the safety net in place, so to speak, or without the expectation or the cultural expectation, as you said, Carol, that there needs to be significant security efforts in place. So I think the first step is simply sort of talking through. You may not think, just sort of talking through this issue with upper management, say, we haven't had to do this in healthcare because we haven't been digitized. Now we are. We're fully digitized, and we've left out this key component. Here's a percentage of an IT budget that is typically devoted to security in the financial services industry. Here's a percentage that's typically devoted to security in a high-functioning healthcare organization. Where is our budget? Why are we not devoting the resources necessary? We need to get ahead of the curve so that our name is not plastered on the front page of the local paper. Having experienced a significant breach is not on the quote-unquote wall of shame maintained by Health and Human Services that identifies folks that have experienced significant breaches. We don't need that kind of PR, so let's get ahead of it.
Yeah. And I never thought about it that way. You're right. This meaningful use, it was part of the HITECH Act passed in 2009 for electronic health record adoption. MU came in 2011. So it hasn't really been that long since the industry has predominantly gone electronic. And certainly in the last couple of years with breaches related to ransomware and cybersecurity is things that providers have not had to have dealt with in the past, and a relatively new phenomenon. So I'm just thinking about it that way, right?
Right, and when people started to sort of work on their HIPAA compliance, a lot of it was paint by numbers, particularly for smaller organizations, though not exclusively smaller organizations. And by that I mean it's like, check the box. Watch the video online once a year. And I've spoken with some people in some organizations, it's the same video every year.
Right.
And they just sort of check the box, and how does that help? When something like ransomware becomes a pervasive issue and you're showing your staff the same video they watched 3 years ago,
right.
they're not going to get sensitized to ransomware.
Right.
They're not going to get sensitized to the latest sort of phishing exploits. And you need to just sort of keep that current, keep it fresh.
Right. Could you please share with us a policy for mobile devices with an associated acknowledgement form? Obviously, mobile devices are, the BYOD kind of phenomenon.
Sure. I mean, there's at one point the notion was that we should simply ban the use of users' own devices, but I think that has mostly gone by the wayside, and we just sort of recognize, particularly since so much is web-based, that it's just going to be, we're going to have to deal with the BYOD situation. I think the questioner is looking for a particular, actual policy. There's certainly quite a number of them available online and searchable. A useful resource that I would recommend is something that's put out by a consortium in Wisconsin that's called HIPAA Cow. Yes.
Oh, you talked about that before. Yeah, right. Well, cows, the middle, they make a lot of cheese up there.
That's right. And right. There are resources, there are policies. It's not something that you can just sort of rip off of their website and use out of the box. It's something that you'll need to customize to your situation. That's the kind of thing that I do with different sorts of covered entities and business associates all the time. But that might at least get your juices flowing, so to speak, get an idea of what you might need to deal with.
Right. How do we ensure vendors are meeting HIPAA regs during the request for proposal process, the vendor selection process? Is it a good idea to ask for their BAAs prior to decision making, since most often with large vendors and smaller practices, they use the vendor's BAA instead of their own? I can see how that would happen, though. They would use the vendor's BAA. That's a good question.
Right. This is one of the classic battle of the forms
Yeah,
questions
yeah.
that we deal with in contracting all the time, whether it's a purchase order or whether it's a business associate agreement. Each party has to comply with the basic regulatory requirements, but there's also obviously additional business terms that get thrown in. If a BAA provided by a large vendor is going to be something that they will insist on having signed, then certainly you'd want to learn about that earlier rather than later. The other part of the question, as I heard it, had to do with trying to figure out whether a vendor is in fact HIPAA compliant as part of the contracting process or the decision-making process.
Right.
And there are a number of programs that very large organizations are now starting to recommend and even require that their vendors participate in. You may have seen some of these acronyms around. One is HITRUST, HITRUST, which is you can be quote-unquote HITRUST certified.
Right.
And that that's the good housekeeping seal of approval, so to speak, and large covered entities, I'm talking about like national health insurance companies, will look for that when they're dealing with vendors in order that they do not have to submit their own, 300-item questionnaire to a vendor to try to determine on a very fact-specific basis, are you HIPAA compliant?
Mm-hmm. Mm-hmm.
So as a smaller organization seeking to contract with service providers, if it's a large service provider, large enough that you think they might insist on using their form of a business associate agreement, they should have some sort of third-party certification available to you that you could, not rely on entirely, but at least it gets you part of the way there in terms of getting a sense that they are in fact HIPAA compliant. HITRUST would be there for some larger organizations. There are also things called SOC 2 reports, SOC-2 or SSAE-16 reports. These are basically certifications by CPA firms that a given vendor is quote-unquote up to snuff in the security department. If you're contracting, for example, with a cloud hosting company like Amazon, you can get their SOC and SSAE reports, so that gives you some level of comfort that they are in fact compliant.
Right, right. If a software program has an error while backing up patient files and all the patient files are deleted, is this a breach? Talking about software.
So the total unavailability of records, and I'm assuming from this question that there isn't a complete backup available that can be restored. So there's sort of two variants of this question. Number one, is the deletion of the record from the main system a breach if the records can be restored in full? The answer to that is no, that's not a breach. If the records are deleted and there's a partial backup, or the most recent backup was a month ago, then yes, that's problematic. And certainly if there's no backup at all, it's extremely problematic. It's obviously just from an operational standpoint that's going to be problematic. One of the rules under HIPAA says that you need to be able to have access to your records. If you don't have access, then you're in violation.
Right, right.
So is it a quote-unquote breach? Perhaps not, because it's not as though somebody else now has access to that data. But it is a violation because you do not have access to that data.
Right. The data has completely disappeared. Completely. Like, right?
So in that circumstance, again, not a data breach,
Right.
but certainly a breach or a violation of HIPAA.
Right. Because as you said, the patient can't get access to their own records at that point. Okay. Um, and of course, if that breaches over 500 records.
Well, again, it's not a data breach. Offhand, I'm not certain whether that would be reportable in
Or
the same
not.
way,
Okay.
but it's certainly a violation.
Okay. Um, with the court case in regards to the possible Fair Credit Reporting Act violation, what could a covered entity potentially do to prepare for an outcome where the defendant is found in violation?
So, as always, the best defense is a good offense. So, the 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 source of the problem in this case is a lost or stolen unencrypted laptop. So for me, that's the beginning and end of the story. Why is there a laptop that's getting stolen that has so much PHI on it that's not encrypted?
Right.
You know, number one, encrypt everything. Number two, why is this stuff even on a laptop? Unclear. You need to limit what you store where, depending on what's really needed. Most of these cases, when we hear about, oh, there were 200,000 patient records on a laptop in somebody's rented car, why?
Well, that's a great question. Like, why? I mean, right.
So I come at this from a prevention perspective. Often, obviously, we come in, we're sort of dealt the facts, once something bad has already happened. But as a general proposition, this is the opportunity for everyone on this call to look at current practices and say, why do all these people have access to all this data? Maybe not all of these people need to have all of this access. Maybe the people who need access don't need access to all of the data, or they don't need access to it all of the time, or they can just have view-only access. Why would they ever need to download it to their own machine and take it off premises, etc.?
Yeah.
Just sort of think through exactly. It's obviously easier to just give open access to everybody within the organization, but even that is technically a violation of HIPAA. Only the minimum necessary information should be accessible to anybody. The only covered person who that doesn't apply to is a healthcare provider, right? Beyond that, we really need to talk about limiting access.
Right. And even at that, encryption products and software are not expensive, and there's a lot of them out there for just, basically encrypting your devices.
Right. I mean, that's sort of a simple step to take.
Right.
So, number one, limit the the what and the where and the who, and then even whatever limited information is out there, encrypt it.
We've got a couple questions related to telehealth, telemedicine, and these consultations that happen via some sort of video platform. Live video platform is usually what happens, of course. And what these folks should be doing to make sure they're securely protecting the data. It's obviously done remote, obviously done through computers, speaking of which, and some sort of video platform. What can they do to make sure that they're doing the right thing as far as protecting the data?
Right. So similar to any vendor, there's a need to sort of do your due diligence with the with the telemedicine platform vendor, have they undergone some sort of HIPAA review? Have they done their own risk assessment? What can they tell you about their HIPAA compliance? What can they tell you about end-to-end encryption? What can they tell you about the software? Is there software that's going to be installed on your machine? Is it all in the cloud? Is their cloud host HIPAA compliant? There's a whole series of issues that you want to look into. That said, there are a number of commercially available products that do meet all of these requirements, and it should not be difficult to find one that would meet your needs at an appropriate price point. There's a whole variety from the relatively bare bones to the very sophisticated enterprise grade, highly customizable sorts of installations that you could use.
Yeah, obviously I don't know if there are providers on the call who are thinking about this, but obviously you can do live video now from both Facebook and Google, and I don't know if those are platforms that people are considering, but certainly they would have to check that out as well with if they were going to go like the live video through Facebook. Or I don't know if I'd recommend that or you would recommend that, but
well, let's explore that for a moment.
Yeah.
That's an interesting question.
Yeah.
So offhand, I don't know if Google Apps, or whatever they call it these days, business associate agreement,
yeah,
covers a live interactive video product. They don't cover, their business associate agreement does not necessarily cover all products. So that's something that you need to check out. So my point is, even if you do have a business associate agreement in place because you're using a commercial version of Google Apps, the particular product may not be covered by the BAA. So that's one consideration. Second consideration is, even if you are using a service that is not technically HIPAA compliant, is this the best way to reach and deal with a particular patient? Does the patient agree, and is the patient willing to sign an authorization for communication with you in a manner that is not quote-unquote secure? Because, as I keep reminding people, all of this structure is built to protect the patient. So if the patient can make an informed decision to waive the security protections, then it is within the patient's rights to do that. I do this when I talk to someone in my doctor's office. I say, I don't want to come in for a screening visit. I want to send you a picture.
Right.
And then I want to make an appointment to actually do something about it, rather than come in one day, come back another day. Blah, blah. So it's up to me. And sometimes I have to be a little forceful in making that clear to the staff person, but I can send a picture. I can engage via video if I feel like it, and my healthcare provider should be able to accommodate that.
Yeah. One of the attendees chatted in, actually before we were addressing this question, asking, is patients waiving privacy a good strategy?
Well, so I don't, it's not something that I would recommend across the board,
yeah,
but it's something that you could do in this context for some sort of limited use case where there's no good alternative. I see this used, I've been involved in arranging to have this sort of approach used for texting,
right,
SMS-based communication,
right,
where it makes sense for certain kinds of communications and certain kinds of patients, and you get the consent to use a non-secure SMS messaging service, because not everybody is going to be able to install the fancy messaging app or whatever it is, but everyone can send a text message. So that's an option, but again, it's an option that should be used um, in limited circumstances because we do have so many tools available that are in fact secure.
Right, right. Is there any liability for visitors, non-employees, non-contractors, snooping for lack of a better term? I'm thinking about the shoulder surfing, leaning over around barriers, shuffling through papers, etc. I'm thinking about using signs, perhaps combined with using existing cameras to discourage such snooping.
I think that, well, to answer the legal question, yes, there is liability. The practical question, you need to think about how can you configure, I assume we're talking about a computer screen. Let's assume we're talking about a computer screen for the moment. There are obviously a number of physical measures that you can take that can reduce the possibility for snooping. So under the security rule, there's a requirement that you have administrative, physical, and technical protections in place that are reasonable and appropriate based on the type of operation that you have. So assuming for the moment that we're talking about the front desk in a physician practice, you should have a polarizing filter on the screen. Right. So you can only read the information on the screen if you're looking at it head-on from a relatively minimal distance. So basically only the person who's sitting at that desk who has presumably signed in, because if you're not using the computer, it should automatically sign you out after a pretty limited period of time. Only that person should be able to be seeing the see the screen. So that might be the end of it. If you're talking about other kinds of information, I mean, when HIPAA was first passed, a lot of people were concerned about all kinds of things, like, oh, I can't call a patient by name because that's a HIPAA violation, or I can't put a patient chart in a bin next to an exam room door because that's going to be a HIPAA violation. That's not a HIPAA violation. But you do need to take reasonable steps to minimize the possibility for this kind of snooping, or else it is a HIPAA violation.
Right. One of the attendees chatted in that 3M provides screen blockers to prevent visual hacking, which is
exactly
right. Which is really what you should be concerned about in these cases. Is not, I mean, snooping, of course, but really the visual hacking side of it, that somebody may want to, for nefarious reasons, be looking at that screen.
Right. We're assuming that we're talking about a computer screen. If it's paper records that are lying about, then there's no magic here. It's sort of a clean desk policy that needs to be in place.
Right. Speaking of nefarious, is a ransomware attack considered a breach that needs to be made aware to patients?
Yes, there's specific guidance on this that has been published by the federal agencies, and that is something that's available via my blog as well. And OCR, the Office of Civil Rights, which enforces HIPAA, issued guidance, I believe, last year on ransomware specifically. Again, this gets back to the issue that we talked about in terms of interfering with the availability of the record, and if it is considered a breach, then yes, patients affected need to be informed of the breach, and depending on the size of the breach, of course, you may need to also inform local press.
Right. That's at 500 threshold, correct?
Correct.
500 right? 500 records or more, right? You mentioned some resources. One of the attendees wanted to know what are the basics that a practice should follow to be compliant, and where could they find that information? They suggested IE Health IT Gov. I think that you can certainly go there, but I think really the best place to start, and agree or not agree with, is the OCR side of that, HHS OCR, right, which has
yes.
state information, and they actually have that they actually have a guide on ransomware and cybersecurity on the OCR, and as well as
Yeah, the OCR website is a terrific resource.
treasure trove.
Some of the information may appear overly technical or regulatory, but there are some items there that are really directed towards, they're really making an effort to be more understandable.
Yeah.
And there's some good information there.
Yeah, and you can, if you go there, you can follow a path as to whether you're a covered entity or a BA too, which is what that's kind of neat as well. So you can kind of pick the direction that you're going in.
That's right. And there's certainly plenty of publications out there, as our attendee mentioned. One website or another, there are, as I said, plenty of publications out there, and I think if you do a couple of Google searches, you'll find some information, and you'll end up finding publications that seem geared to you and your needs. Then you can follow those.
Right. Are you in violation of HIPAA if a teleradiology company loses or fails to back up your exams?
So here, I assume we're talking about a covered entity that contracts out for services with another covered entity, in this case the teleradiology practice, or perhaps with a and there's a business associate in there somewhere that's providing the technical service. So whether you're contracting directly with the other practice or with the business associate, each one of them has an obligation to maintain to deliver the record to you that you were trying to get from them, right? Whether it's a scan or an interpretation. If that is somehow lost, then that's obviously a contract breach. The question is whether it's a data breach under HIPAA. And I think this goes back to our earlier discussion about, is it lost? Is it deleted? Is it gone? Or does somebody else have it? Right? So the unavailability is in fact a breach of the rule. If somebody else has it, then that's also considered a data breach.
Right. I'm going to take one more question, and then we will have to wrap this up. I didn't quite get to everybody's questions today. My apologies. If we didn't get to it, though, of course, we have David's email right in front of you. You can reach out to him directly, and you can, of course, always reach me at carol@hightechanswers.com. What about working with small vendors? What can we require of them to be sure they have taken the steps necessary to protect us and our patient data?
Well, this becomes more of a roll-up-your-sleeves proposition.
Yeah.
And I have been on the receiving end when working with a smaller vendor of those 300-item questionnaires that I've alluded to earlier.
Right.
And that's a daunting prospect for a small vendor to face, but frankly, each of them needs to abide by all of these requirements. So it's important, it is incumbent upon the covered entity to do that due diligence, because not doing the due diligence means that in the event of a breach, you may be liable to the patient.
Right.
Yes, depending on how you've written your contracts and your business associate agreement, you can turn around and try to hold the business associate liable. But if it's that small a company that doesn't have its act together, you may be out of luck. They may have insurance, you may require them to have insurance, but if they have a significant breach, the amount of insurance proceeds available to you may be insignificant.
Yeah, I could see how that would come up with, I mean, I'm just sort of thinking about I'm sure there are practices out there that, their IT company many times, practices that I know, their IT company is a shop of one or two people, you know what I mean?
Right, right.
So I could, it may seem like a burden to answer that 300-point question, but that's what gives you peace of mind as a covered entity.
Right, absolutely.
Yeah.
And each entity in the chain here, covered entity or business associate, is required, well, should be doing a risk assessment on at least an annual basis.
Right, right.
Right? So at the very least, part of your due diligence in dealing with a vendor is show me your HIPAA policies and procedures and show me your most recent risk assessment.
Right, right.
It at least allows you to begin the conversation.
Right. That is great advice. With that, we have gone over our allotted hour. David, thank you so much. We of course will be back again with another HIP chat, and so look for an email from me about when that will be and what we'll be talking about. And of course, to all of the attendees today, thank you. You will get a copy of the recording of this presentation and the PowerPoint with the various contact links. David, thanks again for a wonderful discussion, and we'll see you on the next HIPAA chat.
Thank you, Carol. Thank you all. A pleasure as always.
Yeah. See ya.